This program is brought to you by Emory University.
I want to welcome you to this Alonzo L. McDonald Distinguished Lecture in Christianity and Law. It's wonderful to have you here. Thank you so much for being with us. My name is John Whitty. I serve as Director of the Center for the Study of Law and Religion at Emory University, the host of today's forum. Our center is devoted to studying some of the deep religious sources and dimensions of fundamental questions of law, politics, and society. We work with some 95 faculty from around the Emory campus and some 1,600 scholars from around the world. Our center offers a variety of advanced research projects and publications, degree programs and specialty courses, internships and fellowships, a couple of book series, and a number of public forums and public conferences such as this one. The Alonzo L. McDonald Lecture in Christianity and Law is one of our center's most distinguished forums. It has brought to lecterns around the campus a number of the leading scholars in the country on this topic. Included have been Professor Robert Bella, Professor Jean Bethke Elstein, Professor Martin E. Marty, Professor Nicholas Waltersdorf, the Honorable John T. Noonan Jr., and a number of others. This lecture series is part of a broader project on Christian jurisprudence in the 21st century, Orthodox, Catholic, and Protestant contributions, and that has drawn together an international team of some 24 senior scholars working out of those three dispensations of Christianity and contributing to new outlines of legal and political theology in the 21st century. That project itself has yielded some dozen seminars and conferences, 38 book publications, and hundreds of articles and op-eds that have appeared and will continue to appear in the years ahead. This project and this lecture series have been made possible by the generosity of Ambassador Alonzo L. McDonald. He is one of the proudest sons of Emory University, and he is a trustee of Emory University, emeritus to be sure, but nonetheless very active. And he is a leader of church, of state, of society, and of economy. As a businessman, he has been the world leader of corporations like Bendix, like the McKinsey & Company, like the Avenir Investment Group, and taught for a number of years at Harvard Business School. As a leader of the political realm, he was U.S. Special Ambassador for Trade, negotiating a number of the core private international law instruments and documents that still govern us today, and representing American interests with great alacrity, particularly in Europe. As a leader of the church, he has organized the Trinity Forum, which is a major organ for the teaching of religious and particularly Christian values. He has helped to found a number of convents and monasteries and cloisters on both sides of the Atlantic. And he has been very active through his McDonald Agape Foundation to sponsoring elite scholarship by leading scholars at elite universities in different parts of North America and Western Europe. His design to create some small footprints for Christ, as he says, in the elite academy. And objects of benefaction have included Harvard University, Yale University, Duke University, Cambridge, Oxford, and University of Chicago and Emory. For his creative vision, for his shrewd philanthropy, and for his extraordinarily generous support, I think we owe Ambassador McDonald a very, very robust round of applause. This afternoon, we are deeply privileged to be able to welcome to the McDonald Lectern one of the world's great Protestant theologians, Professor Michael Welker. I had occasion to sit with Cardinal Ratzinger shortly before he became the Pope, and I asked him who he considered to be the top 3 Protestant theologians working in the world. And one of those people was our speaker today, Professor Michael Welker. Educated at the University of Tübingen under Jürgen Moltmann and at the University of Heidelberg thereafter. He currently serves as a chaired professor of systematic theology at the University of Heidelberg. He also is the director of the Innovative Research Project and Center on Interdisciplinary and International Theology. He is the past president and director of Heidelberg's Institute for Advanced Studies. He is a member of the German and the Finnish Academy of Arts and Sciences. He has held distinguished lectureships at Cambridge, at Harvard, at Princeton, at the University of Chicago. He has lectured around the world in a number of different distinguished settings, lecture tours in Brazil and Korea and China, in North America, in Western Europe. He has delivered elite lectureships, endowed the Warfield Lectures at Princeton, the Taylor Lectures at Yale, the DeLench Lectures at Harvard, and now, happily, and finally, the McDonald Lectures at Emory. He is a prolific author. I was feeling a little proud looking at my 2-page resume, and then I opened Professor Welker's resume, and I saw on that resume the list of 300 plus articles, 50 book titles, and growing. And he's still a young man working prolifically on fundamental questions. The trees in Germany are quivering with fear lest they be felled to provide paper for Professor Welker's work. 20 different languages in which his books and articles have appeared. This man deserves the accolade that the Holy Father, before he became the Holy Father, gave to him. The works that you see listed in your program deal with some of the fundamental questions of creation, of Christology, of the Spirit of God, issues of political theology, issues at the intersection, especially of religion and science, the humanities and politics. And we are graced with his presence this semester in our Center for the Study of Law and Religion as he's moving toward a major new set of works dealing with God's justice. It's with great pride and great honor that we have the opportunity to hear one of the great theologians of the world as our Alonzo L. McDonald Distinguished Lecturer, Professor Michael Welker.
John, thank you so much for your all too kind words. I doubt that I can live up to the expectations he rose. I'm most grateful for your kind invitation to speak in the series of the Alonzo L. McDonald Lectures in Christianity and Law, a series founded in 2005 by the McDonald Agape Foundation. And I feel highly honored that Ambassador Alonzo L. McDonald is with us today. Thank you so much. Let me moreover take the opportunity to express my deep gratitude to the Center for the Study of Law and Religion at Emory University in general, and to Professor John Whitty, his colleagues, and his staff, the angels, in particular, for the invitation to spend 3 months here with the chance to enjoy the fruitful exchange of insights and ideas and to work on future projects of international and interdisciplinary research and cooperation. This we share in Heidelberg in our institute and in John Whitty's institute, that we try to create multi-year international interdisciplinary research cooperation between different fields of knowledge on very pressing and fruitful topics. And finally, I should like to thank my colleagues from Candler School of Theology who kindly co-sponsor this event. The first part of my lecture deals with the complicated texture of what is called biblical law. I invite you to join me in the attempt to access the vast normative realm of biblical law by first focusing on a clear intersection with juridical law that is embedded in it. We will concentrate on the connection of law and religion as it was shaped almost 3,000 years ago. The second part of the lecture is concerned with the relation and the difference between the juridical code and the mercy code of the law. We will seek to clarify what the biblical law code means by mercy. The third part will unfold the enormous normative shaping power of mercy, promised by the title of the lecture. not only within biblical law, but also beyond that for any legal and moral orientation towards justice. In the fourth and final part, we turn to the relation of mercy and love. As will be seen, their relation and differentiation, mercy and love, enable us to gain a subtle and nuanced understanding of love, an understanding that moves beyond the familiar definition that says love means eros, agape, philia, which you find in all encyclopedias and textbooks. So the first part, what is biblical law? Biblical talk about law is no less complicated than the use of the term law in legal studies or in the natural sciences. A multi-year international and interdisciplinary cooperation on concepts of law in science, legal studies, and theology, in which I was blessed to have as a strong partner John Whitty with us. This international cooperation on concepts of law in science, legal studies, and theology has taught us we have to explore different complex landscapes when we want to grasp commonalities and differences between perspectives on the law in all these domains of knowledge and orientation. To be sure, the biblical law can shed great light on legal, moral, and theological thinking. But it does not offer illumination in the form of a simple idea or a single clue. In order to mine its insights, we first have to respect its complexity and, at least as scholars, to fear its fogginess. In some Christian communities, all of the Old Testament is termed the law. Some theologians identify the biblical law with a mere figure of thought, the divine demand or the divine imperative. In some Jewish thought, the 5 books of the Torah, that is the 5 books of Moses in the Hebrew Bible, are called the law. It is here within the Torah that we find 3 substantial legal corpora. The book of the covenant, Exodus 20 to 23, the law in Deuteronomy, Deuteronomy 4 to 26 and 29 following, and the priestly law with text spread across Exodus, Leviticus, and Numbers. Moreover, within the Torah, we have 2 versions of what is known as the 10 Commandments, Exodus 20 and Deuteronomy 5. In systematic and practical theology, as well as in many catechisms and in Christian piety, the 10 Commandments have often been regarded as the law in general. Finally, there are texts in the Psalms and in the wisdom traditions that have also been associated with the law and played great role in talk about natural law. So what is the biblical law? A whole canonical book that grew over a millennium, selected texts from the 5 books of Moses, further selected texts from the Hebrew Bible, or the so-called 10 words, the 10 Commandments, which can be regarded as a great tutor in a combination of basic religious ethos and neighborhood ethos. My dear friend and colleague Patrick Miller has written a splendid book on the 10 Commandments. The Swiss Old Testament scholar Konrad Schmid has rightly observed that in the perspective of the Hebrew Bible, on all these levels, the emphatic term law, Torah, means, and I quote him, the one and complete normative, literally codified will of God. The one and only way to a successful life and an adequate relationship to God. Rightly said so. But what exactly is it that God wills? And how can we identify the reliable way to a successful life and the right relationship to God through the law. How is the problem to be avoided that the law and God's will only stand for great ciphers that send all sorts of different signals to different people in different contexts, but leave us at a loss in our search for clear common legal, moral, religious, and also scholarly grounds? For access to these issues, I suggest that we concentrate today on one of the biblical law codes mentioned earlier, a law code that in some parts overlaps with secular law codes, which deal with regular criminal law and tort law. In these texts, the Bible exhibits a clear search for legal justice and connects this endeavor with broader normative and religious concerns. We turn to the Book of the Covenant in Exodus 20 to 23, which many scholars date to the time of 900 or 9000 BCE. And we have the good luck, I can tell you, that in July 2008, Joseph Garfinkel from Hebrew University and his team excavated an ostrakon at Kirbet Yayafa, which we can exactly date around 900. And this shows texts that we find in the law of mercy in the Book of the Covenant. So this is always fantastic for us scholars, because the dating, is it 600, 700, 1300, and so now we have a parallel text, and it says for sure 900. So this law code offers brilliant insights into the interconnection of religious, legal, and moral normativity and thinking. Insights that, as a rule, latently have inspired and guided our humanitarian ethos in many parts of the world up to today. At the core of the Book of the Covenant, we find a collection of juridical regulations that can be termed archaic law, Exodus 21 to 22. These regulations serve the administration of justice and clearly assume a community of equals. After situations of conflict that violate the undisturbed equality, the law seeks to regulate the restoration of this equality via the public administration of justice in the gate. The statutes themselves are composed of two parts: an opening clause with an often quite detailed description of the actus reus, of what the offense is, and a concluding clause that offers the appropriate legal consequence. Both clauses are linked in a conditional if-then formulation. Two examples. Exodus 21:33. If anyone uncovers a pit or digs one and fails to cover it, and an ox or donkey falls into it, then the one who opened the pit must pay so and so. Exodus 21:35. If anyone's bull injures someone else's bull and it dies, the two parties are to sell the live one and divide both the money and the dead animal equally. Whatever was meant by money in those days. Many scholars agree that this so-called casuistic law originally presented the story of a legal conflict and its settlement. Through a process of abstraction, crucial for the law, a process of abstraction, a repeatedly tested experience of restitution that has stood the test of time is then elevated to the level of a legal juridical statute. What is important here is a society's repeated endorsement of the judgment. Yet, in addition to this process of endorsement, in these early laws, we also find a societal and legal interest in appropriate calibration of the various laws and their consistency and coherency with other regulations. Thus, for example, in cases dealing with the theft of cattle, a distinction is made between cases in which the cattle are found in the thief's possession, he shall pay double, and in which they have already been disposed of either through sale to third parties or through consumption of the animal. Exodus 22:1 says, the thief shall pay 5 oxen for 1 oxen and 4 sheep for 1 sheep. A distinction is also made, more serious case, between murder and manslaughter, with each crime carrying different penalties, and many other differentiations. Several important legal ideas or principles can be identified in this so-called archaic legal system. These principles become particularly clear when we look at what is known as the lex talionis, Exodus 21:33 following. In cases involving particular injuries sustained in physical conflict, the legal educator is advised, I quote, if any harm follows, then you shall give life for life, eye for eye, tooth for tooth, hand for hand, foot for foot, burn for burn, wound for wound, stripe for stripe. This often quoted formula, an eye for an eye, a tooth for a tooth, has regularly been misunderstood as the expression of a law of retribution, fed by an injured, subjective sense of justice whose demand for retribution can never be satisfied, a formula condoning and promoting revenge and retaliation. Yet understood in this way, it would lead to the escalation of feuds and the promotion of permanent states of warfare. In contrast, the lex talionis precisely aims at limiting the dynamics and escalation of revenge and retaliation. Thus, one can paraphrase the formula as follows. Only one life for a life. Only one eye for an eye. Only one tooth for a tooth. In this way, it becomes an important step on the long road to more humane solutions, for example, in the form of compensatory payments. Yet strategies for the limitation of conflict are not yet at the level of a legal statute. Brutal processes of intimidation that compel parties to resign themselves to a given state of injustice can also effectively limit conflict. Nor can we simply use the observation that the public is calm as a measure to the success of legal regulations. Without precise criteria, it is impossible to distinguish such a calm state from either low levels of agitation or resigned feelings of oppression. Finally, even some form of active public participation in the regulation of conflict is not yet a sufficient criterion for a law. A public that settles cases of conflict on the basis of remembered analogous precedents or in accordance with long-held customs is yet to reach the formulation and execution of a law. The abstracting power of such a regulation may well give the impression that it has approached the status of a law, but it still remains at the level of a convention, a custom. The level of the law, the grand level of the law is reached, and now it's a little complicated talk, but I would like to invite you to follow it. The level of the law is only reached when the abstractly thematized conflict and the consequences are formulated in such a way that they can be applied to other parallel forms of conflict and their consequences. Then, to refer back to the initial example, the concern is not only the theft of cattle in its various forms, A, B, C, D, donkeys, and so on. The theft of grain can likewise be dealt with, also in its various forms, A, B, C, D, or even that of human beings. Such cases, as well as, for example, bodily injury, are considered under a leading motive and subsequently regulated in accordance with the principle of limiting the conflict, the principle of preventing escalation, the principle of restitution, or the principle of equal damage if restitution is not possible. It is at this second level of abstraction that we find the maintenance of principles that connect the defined actus reus, the tort done or the offense done, and its respective legal consequences across the most varied of contexts. These regulative legal ideas or principles can now be applied back to the definition and understanding of the legal case and to the formulation of a measured limiting penalty. And I can tell you, we have just examined in contact with the Max Planck Institute of International Law, dogmatics in theology and law. And this rationality is still up to date. So the way how laws are generated and what their inner power and dynamic and rationality are all about. 3,000 years. In the cases just examined, the process of equalizing restitution or equal damage as understood through the casuistic law and the lex talionis functions as a constraint. Cases are presented because of a need for restitution or balance. They are closed once that equalizing restitution or equal harm has been accomplished. It is in light of this process of restitution or balancing harm that the entire case is understood, defined, and limited. Trying to seek compensation for the awarded restitution or the experienced harm is out of the question. Then we are back in the retaliation process. A case once closed by an act of restitution or punishment cannot be continued. The early stages of the law, as we find them in the Old Testament, respectively the Hebrew Bible, respond to individual intrusions that endangers another party's security of expectation in the normal course of life. The intention of the law is to remedy conflicts, thus defined by restoring a pre-conflict state of affairs, or when this is impossible, limiting the conflict through an equalizing restitution, or in the worst cases, through an equal damage to the offending side. Here we stand before one of the most impressive achievements of early legal thought and legal thought in general. Through the legal standardization of concrete conflicts, their connections and consequences already become largely foreseeable. Due to the abstraction and objectification of the law, they can in principle be treated in the same way as previous conflicts. When conflicts are understood legally, they can be identified as an already existent problem whose resolution is not only well known, but also as good as accomplished. They are resolvable, soluble, a state that is already effected in their very comprehension and diagnosis. The conflict that has to be dealt with is not something of incomparable individuality and incomprehensible intricacy, but rather an event that has already been identified as something known, something already existent, a past present with its past future, a present whose continuation is now foreseeable and well known, and whose conclusion is reproducible and is now being repeated. Cases and problems standardized at the level of the law just become resolvable problems precisely because of this legal process of comprehension. What we are dealing with here are processes of experience and of discovery, results of which cannot simply be attributed to the determination of authority or habit. The development of the law would be a process of normative delusions and confusions in which long-term progression and retrogression, development and degeneration would become indistinguishable if in this development there were not also some process aimed at the discovery in the nature of things. And in this process of discovery, the power of mercy plays a crucial role. I come to the second part, shorter part, justice and mercy and biblical law. The legal statutes at the core of the Book of the Covenant are preceded by the so-called slave laws, Exodus 21, 1 to 11. The primary expression of these laws reads, if you buy a Hebrew servant, he is to serve you for 6 years. But in the 7th year he shall go free, without paying anything. Although this law also presupposes a process of restitution, it differs from the casuistic law of the Book of the Covenant in that these open with a description of a pressing conflict and close with the pronouncement of a corresponding legal compensation or punishment. Since the Book of the Covenant is framed at both the beginning and the end with cultic regulations, the third group, regulations with laws concerning the worship of God, one might wonder if the slave laws also constitute a second bracketing, frame around the core set of juridical regulations we just examined. If so, then toward the end of the Book of the Covenant, before the closing set of cultic laws, we would expect to find a matching collection of laws that are similarly distinct from both the standard juridical statutes and the cultic directives. And indeed, this is precisely the case. In Exodus 22, the latter set deals with the protection of foreigners, the widows and orphans, the poor, those who are ostracized, vulnerable, and powerless, and it even regulates behavior toward opponents and enemies. On the one hand, these laws that constituted what I have termed the mercy code of the law, and that are often formulated as apodictic statements, on the one hand, these laws are clearly distinguishable from the juridical and cultic codes. Yet on the other hand, at times they are presented in mixed forms, connected and interwoven with the two other legal codes. For example, cultic regulations regarding the Sabbath day and Sabbath year also expressly detail benefits for slaves and foreigners. Common to the mercy code is the demand that the strong defer to the acutely or chronically weak or actively engage with them for the latter's benefit. Although the laws often have the character of a moral appeal, they are not simply envisioning the random performance of compassion by the strong. By making the protection of the weaker a focus of the law, it ensures that the practice of mercy is not tied simply to the arbitrary or capricious inclinations of the stronger individual. It moves the act of compassion beyond the moral virtue, even beyond the level of a moral duty. Here too, there should be security of expectation with regard to the practiced mercy. The pressures of expectations are applied to one's behavior toward the acutely and chronically weak, a pressure that has the equalization of legal relationships as its goal. Here you see already the first roots of our today, human rights laws. Very important. These laws of compassion are accompanied by the discovery of new formative opportunities in the evolution of the law. This is already clear in the primary version of the slave laws just examined. If you buy a Hebrew servant, he is to serve you for 6 years, but in the 7th year he shall go free without paying anything. Here the law formally formally elevates slavery, a fact of life in ancient Near Eastern societies, and an integral part of the economic and social order, here the law formulates slavery to the status of a conflict in need of resolution. Thus, the law does not simply focus on overcoming acute and short-term legal conflicts, but rather focuses on long-term processes of transformation that reshape unequal relationships into ones between equals. For Hebrew slaves, this bears enormous consequences. It means that they are to be respected and treated as potentially free persons. A status not dependent upon the capriciousness of their owners, but upon the authority of the law. The consequences of this move can be found in a number of statutes. I give you only one example, Exodus 21:20, when a slave owner strikes a male or female slave with a rod so that the slave dies as a direct result, that slave's death must be avenged. By no means are slaves to be seen as exploitable speaking tools, a Roman phrase, to be treated according to their owner's whim. I come to the third part. The normative shaping power of mercy in the biblical law and beyond. Mercy? Isn't this a surplus, a luxury phenomenon in well-ordered and well-functioning societies? Shouldn't we reserve this term for the rare cases that we call an appeal for mercy, plea for clemency, or clemency petition? With this remark, a law professor from the Heidelberg Max Planck Institute for International Law alerted me to the fact that the biblical and theological pairing of justice and mercy perhaps cannot be easily introduced into secular context today. We appreciate the talk of love and compassion as rule in person-to-person relation, but the talk of mercy seems to be outdated for many people, at least today in Europe. It belongs to a group of religious words that sound increasingly strange to many of our contemporaries. This is certainly the case with respect to sin, sacrifice, atonement, but even such notions as covenant and mercy are moving into the area of strange talk. I should like to argue that a new familiarity with the biblical law and its formative insights might help people in our time to overcome this loss of normative sensitivity and thinking. What do the laws of mercy expect from human beings? They limit the time of slavery and the potentials of the slave owners to make use of the working power of the slave, not only after 6 years, but also on the Sabbath. They normatively expect a self-withdrawal from the use of these powers once each week and after 6 years. The Deuteronomic law even expects the owner, I quote a recent book by Richard Hare's Justice and Compassion in Biblical Law, the Deuteronomic law expects the owner to contribute generous provisions for the former slave's new life of freedom. Deuteronomy 15:13 following. The law does not exactly determine these provisions. It clearly prohibits the exploitation of slaves, widows, orphans, the poor, and the strangers. But it leaves the detail of support and potential generosity open. The Mercy Code thus aims at what I have called the free and creative self-withdrawal in favor of others. The free and creative self-withdrawal in the favor of others. It blocks the dangers of ignoring or exploiting the poor and the needy, and it encourages creative moral and practical benevolence, even at stages when it determines amounts of tithing and social taxes. So we have the routinization, tithing, social taxes, but yet also the open space for moral imagination and engagement. The free and creative self-withdrawal in favor of others leaves open space for moral imagination and practical activity. But how can this find a place beside and in conjunction with juridical law, which aims at securing expectations in cases of legal conflicts. 3 answers, in my view, are important to reveal the power of mercy in the biblical law. First, we have to see that the mercy code can draw from evident experiences in family life. Each human being is, at least as a child, but also in situations of illness and sadness, and in most cases at the end of one's life, in need of a creative self-withdrawal of others in his or her favor. In these cases, we speak as a rule of family love, and we will come back to this topic. Thus, the behavior and the experience that the mercy code activates are by no means unfamiliar to human beings. Second, the biblical law now moves these experiences and behaviors beyond the area of the family into a broad social realm. This realm becomes visible in the third group of laws that surround the judicial laws and the mercy laws, namely the cultic laws. These laws regulate the worship and the right communal encounter of human beings with God. Family experiences on the one hand and religious experience, memory and imagination on the other, are connected to foster an ethos in which the striving for justice and mercy can flourish. We know only little about the early cultic constitution of the public sphere. And yet the clues offered by the legal traditions make us see that the cultic public ascribed to itself the status of a people and nation, one that has been freed from slavery in Egypt by God's mighty hand and outstretched arm. The so-called motive clause of the law says, "You yourself were once foreigners in Egypt." The clause and its expanded form, "You yourself know how it feels to be a foreigner," can be found not only in the Book of the Covenant, but also throughout all the Old Testament legal corpora. So the motive clause, "You have been a stranger, now you are free," across the legal corpora. The behavior and self-understanding of this community before God is also defined by God's own historical interventions into the life of the community. These interventions give rise to historical experiences that mold the self-understanding of the community and their view of reality. God's interventions in the human sphere of life become the primary event of cultic communication. Yet at the same time, these experiences of God extend beyond the possible concrete experiences of the cultic public sphere. Even those who were never personally in Egypt allow themselves to be addressed as those who were slaves and freed by God's hand. They allow themselves to be embedded into a network of experiences in a public collective that transcends the realm of personally attainable experience. In this way, the paradigmatic sphere of cultic communication transcends epochs. Yet why was this double identity, "you were a foreigner, yet now you are free," not simply discarded or abandoned? Why were these legal and moral impositions of the mercy code not rejected? What drove Israel not to grudgingly persevere with the attribution of such a wide-ranging historical identity and with the life spread across broad horizons of time, but to joyfully accept it? How did the law come to serve as a bearer of paradigmatic memory? Here too we are dealing with the discovery of great religious relevance and explanatory power, but also normative relevance. At each discrete point in time, people are incredibly unequal. Yet this changes when we picture ourselves on an extended timeline and see both young and old, sick and weak, not only with us, but also in us. This fosters a sensitivity to the fragility of all human life, which in turn promotes the co-evolution of the religious, legal, and compassionate moral codes that we encountered in the biblical law. With the motive clause, Israel expands this foundational experience of natural life into an historical dimension. It transposes the sensibilities of familial solidarity into a historical socio-political dimension. Thirdly, a set of no less than 7 observations can shortly summarize and fully unfold our appreciation of the power of mercy in biblical law. It reflects above all the mutual normative power, the mutual normative strengthening of the mercy code and the juridical code in the biblical context, but also in many cultures in general. First, with the slave law, the biblical mercy law institutes forms that are also important for the judicial side of the law. The law is not only an instrument of short-term conflict solution, but also a power of long-term social transformation. It awakens and binds individual and public attention in long-term memory and imagination. Second, the mercy law sustains values of social welfare, freedom, and equality. It gains enormous political functions and enables the juridical law to become a moral teacher. By no means did this occur only in biblical times, but takes place also today, as Kathleen Keaveney has argued in her recent book, Law's Virtues, Fostering Autonomy and Solidarity in American Society. We just discussed this book a few days ago. Third, the mercy law not only shapes moral and political moods in formative ways, but it also draws impulses from and recursively strengthens the family ethos. In biblical times, this ethos was clearly connected with patriarchal structures, no way. The merciful father was at the center of attention in family life, political life, and religious communication. Even perspectives critical of this role of patriarchy in the shaping of normative expectations should appreciate that it replaces the king as the sole executor of mercy and of clemency appeals. So we see already a move. Fourth, the mercy law also connects the religious orientation with clear legal and moral attempts to strive for justice and expectable care for the weak. With the religious perspectives, it opens broad historical horizons that even extend memories and expectations beyond the 6 years of slavery. The just and righteous God will deal with human beings in time spans that reach far beyond the imagination of human courts or of individual and communal moral memory. So strong moral appeals connected with religious perspectives. Fifth, the mercy law also has an enormous impact on individual personal identities. Human beings who are able to experience and exercise a free and creative self-withdrawal in favor of others move continuously beyond the perspectives of self-sustenance and self-preservation. They move continuously beyond what biblical traditions call a merely fleshly experience and existence. In the perspective of the law, the slaves are potentially free persons. In the perspective of the law, all Israelites can regard themselves in the enormous spectrum of persons who have been slaves in Egypt and are now free. All Israelites can regard themselves as people of a great salvific history. They possess differentiated identities who can put themselves in the shoes or sandals of the poor and on the thrones of the rich and famous. Sixth, in a direct impact on the juridical law, the mercy law strengthens and challenges the former's competence. On the one hand, no case is imaginable which could fall below the competence of the law. No person, however weak, poor, and miserable, will fall below the levels of the outreach of the law. On the other, the systematic orientation of the law towards compassion demands the continual refinement of the legal culture and its directedness towards universalization. So the power of the juridical law, the outreach power, is correlated with the correlation of justice and mercy. Finally, seventh, the mercy code of the law helps us in dealing with the painful paradox plaguing all legal and moral evolution. Huge paradox. We want to improve our juridical law. We want to develop and cultivate our human morality. How can we take on this difficult yet unavoidable task of transforming and improving normative potentials without in this process destroying their binding powers? Juridical law and human morals need normative stability. They are to provide security of expectations. Here the mercy code has a balancing function. Dynamics as well as stability are enabled when justice and mercy, law and compassion are put in a creative tension and in cooperation. We are staying on our way, but we are improving. Finally, a short part on mercy and love. Mercy and love are neighboring terms, but they are not identical. Whereas mercy is the free creative self-withdrawal in favor of the other or others, love is the joyful free creative self-withdrawal in favor of the other or others. At first glance, with regard to love, this definition of self-withdrawal sounds counterintuitive. Do we not want to be as close as possible to the beloved person? Do the notions of unity and deep connectedness and also the notions of self-giving, are they not much more adequately definitions of love than this strange talk about self-withdrawal? But we have to remain subtle. In love, we are not just focusing on any type of self-withdrawal. Loving self-withdrawal is joyful, free, and creative, and in favor of the beloved. But why do we talk of self-withdrawal at all? Here a most important element of love comes into view, which is very often sadly overlooked. This is the element of freedom in love. Love seeks the free development of the beloved person and a free response. In a loving relationship, we do not only respect the depth and potential richness of the other person's identity, but we rejoice in sharing and discovering ever new dimensions of the beloved one. We also rejoice in disclosing our own life in its fullness in order to share it with the beloved person to a maximum degree. With respect to pain and suffering of the beloved person, we passionately feel the deficiencies and the lack of opportunities and strive for compensation and healing. The mathematician and philosopher Alfred North Whitehead captured this in his brilliant insight that love might be understood on the basis of a parent-child, a marriage relation, as, I quote him, a self-devotion where the potentialities of the loved one are felt passionately as a claim that it finds itself in a friendly universe. I find this fascinating. A self-devotion where the potentialities of the loved one are felt passionately as a claim that it finds itself in a friendly universe. Such love, Whitehead says, is really an intense feeling as to how the harmony of the world should be realized in particular persons and objects. Strong. With this deep understanding of love, we see why romantic love can be regarded as the ideal form of love and why it can absorb all perspectives on love. Love wants to elicit free response. The ultimate joy of love is indeed a mutual igniting which is imagined and experienced in spiritual and erotic lively exchange and union. No question. But this covers by no means the full spectrum of love. True love, and here we have to sing the praise of covenantal love over erotic love, true love moves through thick and thin. It wants to elicit response and mutual igniting power, to be sure. but it also lives in perseverance, faith, and hope through phases of no direct response. This is the secret why love is as strong as death, as the Song of Songs 8:6 says. The understanding of this power of love invites us to gain a deep sense of joy, clearly differentiated from mere excitement, fun, or pleasure. It gives a sense for the richness and depth of love. Love is ultimately a gift of the Holy Spirit, which pours it out in our hearts and does not only fill our heart, but also our flesh and our body, our mind and our soul, our reason and our spirit. Given this richness, Paul rightly emphasizes the enormous multitude of perseverant powers in love in 1 Corinthians 13. I cannot quote it because of the pressure of time. And Paul speaks of the joy given by the Holy Spirit, even in much affliction. 1 Thessalonians 1:6. There are, of course, and I come to the end, boundaries, where we can no longer imagine joy in the suffering or kenotic or self-sacrificial love. There are boundaries where we are simply not able to follow the command to love our enemies with a joyful heart, where we even think it is just absurd. At these boundaries, we should honor those who practice love not only with little or even no response from the beloved person. Some of us call them saints, but we have a multitude of at least temporary saints in family life, social, therapeutic work, and offices. If you start imagining, you will be overwhelmed. On the other hand, at these boundaries, there is the dignity of mercy, the free creative self-withdrawal in favor of others without the blessings of joy that love will give. The power of mercy does not only strengthen and disclose the other dimension of the law just as justice and worship. We have barely touched on the rich dimensions of worship and cult, that is, the encounter with God's justice and mercy, the deep joy in the glorification of the merciful God, and the many forms of doxology. That would be another lecture. The understanding of mercy also opens our eyes for the deeper secrets of love, which is, to quote Matthew and Paul at the end, the sum and the fulfillment of the law. Thank you very much.
We have more work for you to do. The works righteousness is a very important feature, but I think we got to give another round of applause for a great lecture.
We have a global humanitarian summit here, April 12th, 13th, 14th. We've had 1,500 people attend, and it's free, and 200 speakers or 100 speakers, and they're from every religion. Yeah. And they basically profess what you say, but when you get them together, it's very magical. Yeah. And the hope is that other schools all over the world will have similar summits. Yeah. I had a specific question, though, and this relates to the worst thing going on in the world right now, which is the Congo crisis and millions of young girls being raped and killed. And I just wonder, we had one church here in Atlanta that has had events talking about this, but practically all religious groups seem to ignore this. It's like the Holocaust, and it's known to the world because all you have to do is go to Google and you can find, you can go on the internet. Do you have any explanation for why all the religions in the world are ignoring this tragedy and not speaking out so that people go in and arrest these people?
Well,
UN,
yeah, it's. I think you are raising a very, very complicated question in the organizing of our societies. When you have these impressive meetings of 1,500 people, some of them have loyalty in their own churches. Others are just sent as a kind of person which comes back and gives a report and nobody hears it. I think it's an enormous, it's a question, how can churches and civil society organizations deal with this enormous amount of suffering and violence on this globe? And I think what we need is, on the one hand, clear ground forms, what we are looking after, so that you do not get all the tensions between religious institutions and secular institutions and different religions and all sorts of groups coming up again and again. And this is why we are so passionate to look for legal grounds in the religious traditions, that we can share and that we can join forces between legal and religious powers. On the other hand, I think it will be very important that specific governments shoulder specific responsibilities. And so here is my high hope that the ecumeny will, instead of having these huge conferences where they declare some very general things, we are all for justice, mercy, and the rescue of creation and so on, that they will deal with maps of mapping conflicts in different areas of the world and also attributing responsibilities of former, often colonial, countries who should now have an impact on these developments. If you just want to alert the whole world, well, then Karl Barth once spoke of a moral warfare of all against all. This is too much complexity. And I think it is very important that we have maps of conflicts and that we then say, you are responsible for this and you are responsible for that. So on the one hand, sharing clear connections, getting very good grounds in our faith traditions, in the interaction between different religious traditions, but also with law, politics, economy, and media and so on, is very crucial. But also the calibration of conflicts so that not all big conflicts immediately approach the whole global community. Then you get only media responses. When it burns very highly, you are for 2 days in the newspapers, and then things are over.
Professor Naim.
Thank you. I was very intrigued by the remark you said that your German international law colleague said about the relationship between these biblical notions and secular law today. How did you understand that? What does it mean, and what do you see the way into either exploring that possibility or otherwise dealing with it?
Well, it was one step on the way to really approach each other, also on German grounds, where we want to see the formative potentials in legal thinking and in religious thinking, and really hardcore, the great canonical texts, where we can see where can we build alliances and where can we mutually strengthen each other. So in a way, we are trying to do today what the biblical law codes try to do in their time. And I think we are quite successful. So in the beginning, we just read classics together, but now we are already on the level that we see what are the structures of legal and theological dogmatics. Do we see similarities? How are they developed? How can we improve these? And how can we learn from each other? So we are moving in cousinly relations and good cooperation. But of course, you get also these elements where you get the warning and say, well, if you continue this kind of talk without explanation, then we have difficulties to understand it. And I think that we are here really dealing with the discovery of deep rationalities involved in realities, in our family reality and others. I was struck that Germany, after the atrocities of the Third Reich and the Second World War, tried to regain recognition in the international community by understanding itself as a state of law and a state of welfare. Justice and mercy in the biblical law. Great Jewish insights, 3,000 years old, roots already in Egypt, and so on. So I think it was a very good choice that Germany did. Today they might call it a state of, I don't know, commerce and entertainment, or I don't know. So you see, it is very important that we help our cultures to discover these deep roots, to honor the rationalities, to see the ennoblement that lies in the discovery of these great roots, and then to make them operative in different religious, legal, political, moral, and other contexts.
The preceding program is copyrighted by Emory University.